I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor
Magoo, we
for
go
the,
through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. Oh, gosh, yes. Ready. Here we go. I spend my life ready. You sure?
Yes, sir.
In anticipation about what I'm going to go through right now, this is absolutely all your fault.
Oh. In anticipation.
In anticipation of it, I'm just letting you know.
Well, let me apologize in anticipation for this being my fault. I am sorry.
Court does call the case of the people versus Daniel Magoo. State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523. I have a couple things I'd like to point out about a couple of the matters here today.
What?
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid on
That were
its
going to
face.
be addressed. That would be addressed at the preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all 3.
Sir, do
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting all the charges are dismissed, a motion for all dismissal on all these charges.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Ms. Lobby has let me know that all paper discovery has been sent to Mr. McGowan in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McGowan, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the
He
video.
has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. Magoo, are you gonna have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So given that, that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to
All
a
right.
speedy
So
trial.
you want your preliminary examination. Those are coming down to the jail to him.
I expect that you would have them early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th and
to
then
have them in well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 4 different counts, or 5 different counts, excuse me, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a 3rd offense notice, which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, yeah, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I will. I have requested assistance, given that I am incarcerated and I have no way to.
You wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor.
Magoo, we
for
go
the-
through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent
If
you. That is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge Torsia, Feaster, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting a release, Your Honor, PR bond.
A response from the people regarding his bond.
People would ask the bond to continue, and he also at the bench warrant failed to appear before the judge's play. So
Yes.
that warrant would also hold up with respect to the other. I'll wait. There are pleadings filed by the public defender's office. Our office will respond to that. And I guess my one remaining point would be, with the court's appointment to Eastern the Public Defender's Office, I will make sure that the digital discovery that I referenced is served on the Public Defender's Office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied, so.
That's what I
would
Mr. Choda said.
in any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding, police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And,
I understand the presumption of innocence.
well, and a lot of these are
Every day for
facially
26
invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Or the custody of.
I was dropped off at the hospital and they later tacked on
And
charges,
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out. And that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh, yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. Complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I would deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for the Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So.
I'm aware that such note or such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case until I did otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, Denied.
Thank you very much, Judge.
Bond will continue. Thank you.
Somebody be able to continue.
Court does call the case of the people of the state of Michigan versus Larry Lee.
Good afternoon, Your Honor. Retail Assistant Prosecuting Attorney on behalf of the people.
State your name, please, sir. Mr. Lee, you are here for your preliminary examination. Sir, you have elected to represent yourself. Is that still your wish, sir?
Your Honor, I have not received any of the requested discovery material. I've sent out written requests for the prosecution and my previous attorney and haven't received anything. So at this point, I'll be needing an attorney to assist, to represent me.
Your Honor, if Mr. Lee can maybe put on the record where he sent that request. I have not been informed of the discovery request from him. My understanding was that Mr. Burgess had a discovery materials.
I sent it to 200 North Main Street.
But well, there are two issues really involved. You sent out that you wanted a copy of your discovery.
That is correct.
Are you indicating that Mr. Burgess did not provide or share with you your discovery?
Correct. I sent out one to the prosecutor and one to Mr. Burgess.
Now, I'm asking a different question. At the point in time that Mr. Burgess is representing you, are you saying that he did not share the discovery information with you?
The only thing that I received was a police report, a 2-page report. That's it. So I didn't receive the file that he was referring to last court hearing. I didn't receive that, no.
All right, let's just cut through the games and charade here. Do you wish to be represented by an attorney?
At this point, yes, I don't have any material.
Well, it's not an issue of the material. Do you wish to have an attorney represent you?
Yes.
Okay, under the court rule, he is entitled and can ask for that at any point in time. This is probably going to cause great inconvenience for people, but. And now here's the weird part of the system. While Mr. Drukas, I've appointed as standby counsel, I need you to get to the MAC office. Take him back. We'll get that resolved, figure out what the MAC office wants to do.
When we come back, I just want to make sure I don't forget, there are a few things that you want to address that happened after the last court hearing. So we can do that when we come back.
Something that happened after the last.
Yes, Your Honor.
You were just full of surprises. Fine, I'll deal with it then. Court's going to stand in recess.
All right.
Court does recall the case of the people versus Larry Lee.
Your Honor, Retail Assistant Prosecuting Attorney on behalf of the people.
Good afternoon, Edward Lucas on behalf of Larry Lee.
All right. Mr. Lee, I've signed the order appointing Mr. Dukas to represent you in this matter so that you're aware.
Thank you.
Okay, all right. So in this matter,
Set for a preliminary examination, I'm asking for a brief adjournment. I understand through timing with the court that Monday morning would be available. If we could set it for that time.
All right.
Opportunity to go over discovery.
will that work for the people?
Yes, Your Honor. We'll have witnesses present.
All right. So preliminary examination in this matter will be adjourned. Court finding good cause to do so. I will adjourn it to, what is it, the 11th?
Yes.
August 11th, 2025, 9 a.m.
Thank you, Your Honor.
For me.
And, when the court's ready, I have a couple of matters to put on the record.
Yes.
Your Honor, first and foremost, after the last hearing we were here for, the victim was present with a support person. As they were leaving the courthouse, they were addressed by someone who identified themselves as the friend of Larry Lee. I believe that person is now sitting in the gallery here today. I've personally warned her, but I would appreciate it if we could repeat that on the record, that the victim is not to be talked to or contacted. I don't have anything indicating that Mr. Lee directed that contact, but I want to make sure everybody's clear so we don't have any further issues regarding contact with the victim of this case.
All right. And which individual are you referring to?
This is like it right now.
Emma, you come out this way. What's,
Hi.
hello, what's your name?
Hello, Your Honor.
What's your name?
I'm Jeanette Thompson.
What did you want to tell me?
Okay, so just to begin here, I'm very respectful. I don't know nothing that happened. When the I believe it's the victim was walking out, he was staring at me and I'm with 3 different women. And since he was staring at me, I said, are you so-and-so? I could identify him. So I think he was just irate because of what he going through. I don't know. But to be honest, I don't know that man. When he was talking, he was using verbal language. He walked back towards me and 3 other women and was kind of upset. And I said, I just want to know if you okay. My bad. I could identify him. That was all it was. I just said, I just want to know you okay. I don't.
Okay, so just stop it right now.
Yes.
So I don't want you to have any contact with the legislature in this case whatsoever. It doesn't matter if you are worried about whether or not they're doing okay or anything along those lines. You just not to have any contact. Because ultimately, while the people don't have proof that Mr. Lee's involved with that, it could be attributed to him in regard to the behavior, and I don't think you want that to occur. All right? So I don't want any contact whatsoever. I understood.
Yes, sir.
All right? And if I do find out there is, at minimum, I would have you report.
Well, please, can you tell him not to walk up on me
I am
again?
not gonna tell him that.
Okay, because that was
You
just
are, well, hold on. Here's part of the court proceeding.
right.
You are not.
Correct.
So you need to, if it's necessary, you need to get out of his way. There's court security if that
Got it.
becomes an issue for you.
Okay.
Or you can just make the election that you do not need to appear. If you want to see the proceeding that is happening with Mr. Lee, then certainly you may view that on YouTube. So there isn't a reason for you to be here.
Mhm.
There is a reason for him to be here.
Got it. Okay.
Understood?
Yes, sir.
All right, thank you. You can have a seat.
Thank you, Honor. One other thing regarding the discovery request that Mr. Lee said he had sent one to our office. I just received the email. It was labeled a FOIA request, so it went to our appeals and FOIA department. It appears it's a mix of, and I'll make sure to share this with Mr. Drukas, but essentially, it appears he is attempting to FOIA communication that I may have had with the court, that I may have had with Mr. Burgess. There's also a grievance / investigation request looking to, it appears, grieve me, potentially more people. I haven't read through the whole thing. Somewhere in there's mention that he wants anything related to this case, but the overall idea and heading is FOIAing all communications that have happened in this case, as well as attempting to grieve myself and potentially other people. So I know at this point, Mr. Drukas is appointed, he'll get all the discovery. We've been in communication. I've asked our office to expedite the video discovery to him. I handed him a report that's unredacted, but it is the full police report. So we'll take care of that. But perhaps there should be a conversation Mr. Drukas wants to have with Mr. Lee about the rest of it and anything that may or may not be brought up as part of this case, and that the grievance process is a separate process, which he is entitled to.
Right. If that's what he wishes to do. All right. Anything more?
Nothing further.
All right. Very good. Thank you, folks.
Thank you, Ron.
Everybody have a great weekend.
Thank you.
Bond will continue at this time. We'll see you Monday morning. Thank you for this week. It's been enjoyable and always, Anna, great job. We are done finally with this week. Next week will be better. 14 stands adjourned.